David, myth or truth? If I get an inheritance, is the inheritance off limit in the divorce?
So there's myth and truth in that. It is true that if you get an inheritance during your marriage, it is separate property and it is not marital property. Where people get into trouble is when they take that inheritance and put it into their marital checking account, or they buy a home with it and put their spouse on the title. They have now taken that inheritance and made it a gift to the marriage. So our caution to clients who are going to receive an inheritance while they're married, if they want to keep that as separate property, is to keep it in a separate account, not mingle it with marital funds, and not use it to make purchases for the marriage. The minute you start spending that money on the marriage, that amount you spent becomes a marital asset and a gift to the marriage.
And then we're stuck with trying to make an equity argument because there's language that if you depleted your separate property for marital purposes, you can ask the court to give you an offset of that. But that's an equity argument. That I always liken that to asking the court for a cookie. You ask somebody for a cookie, they could say, oh, you're so cute, here's a cookie. They could say, did you eat your lunch? You can't have a cookie. They could say, have a carrot. So you don't want to be in the position of making an equity argument when you can do what David's just suggested and keep your money separate.
And one more example I think is important is that a lot of people in the inheritance, rather than get money, they get property. They get their grandfather's hot rod or a tractor or jewelry. And as long as you keep that in your name and don't add your spouse to the title, you're going to be able to keep that inherited piece of property as separate property.